Okay, it's looking like Miss Faith is not available to lead us with the opening prayer. Or is she shy? I mean, opening prayer should not be something that you're shy of, except you just don't want to talk to us. Okay, that's not a problem. In the absence of Miss Faith, can Miss Bamidele Comfort? I'm sorry if I missed that, but can Miss Bamidele Comfort lead us in the opening prayer? You don't have to switch on your video. You can just unmute yourself or type the prayer in the chat box.
Sorry, the host or co-host, you have to unmute anybody that you are talking to. I think Abraham can manage that.
Okay, sir.
Good afternoon, everyone.
Good afternoon.
Yeah, we come in this program. We start with the name of the Father, the name of the Son, and the name of the Holy Spirit.
I'm so sorry for the break in transmission. MTN had a lot to do at the moment. So once again, my name is Ifeoluwa Deborah Akishola, and I am going to be your moderator for this webinar. And I am glad and delighted to welcome you to the maiden edition of the Students Association of College of Law webinar. And before I move on, I want to do a quick test run to see how many of us were prepared or are prepared for this webinar. So can someone type the topic of this webinar in the chat box? You never know if you are getting something from me or from any of the executives. So can somebody type the topic of this webinar in the chat box very quickly? I do not want us to waste so much time as our speakers have a lot to say to us. So somebody, anybody? At least now I'm not asking you people to unmute your mic or switch on your video. So you can just type the topic in the chat box if you were actually prepared for this webinar. So anybody? Okay. So Kale Somi, I'm sorry if I pronounce your name wrong. I'm so sorry. Kale Somi Adela just says, exploring the nexus between criminality, conflict resolution, and the legal system. Thank you very much. That is the topic of our webinar. So I welcome you to JUSTICIA CONIUNCTIO, SACOL Executive. I'm sorry if my pronunciation is wrong. I'm just a Nigerian. And we are exploring the nexus between criminality, conflict resolution, and legal systems. So we all know how crime, emergence of conflict, and legal system, I mean, they have a common ground, they are interwoven. But this now begs the question, what is the common ground they have? How are they interwoven, and how do they work together to help in resolving conflicts in our everyday society? So that is what we are here to learn today. We are here to learn how law as a discipline, criminology as a discipline, and peace and conflict resolution as a discipline all come together with their respective expertise to bring us a balanced society today. So therefore, I need you all to pay rapt attention as our speakers give us the best of their knowledge. I need you all to write down. See, I have my jotter, I have a pen with me. I'm also here to learn. So I need us all to listen, to write, to learn as much as we can. So when we go out there and people ask us, you are a law student, you are a criminology student, how does your discipline work in relation with other disciplines to bring about a balanced society? So once again, I want to remind us, the national grid may collapse 7 times, but you should not allow your attention for this webinar to collapse. Thank you very much. So very quickly, so to know that we are all following me, to know that we are not just here on the call and not listening to anything I'm saying, please type it in the chat box that I am ready to learn. Kindly type it in the chat box. I am ready to learn. I am ready to learn. I want to be sure the SACOL executives and the speakers are not the only one here on this call today. So kindly type it in the chat box. I am ready to learn. Samuel Lawal, thank you. Olufunke Dari, thank you. Bamidele Comfort, I asked you to lead opening prayer. I'm coming back for you. Faith and Yola, you too, no problem. I know what I will do to you people. Oluwakoinsola Olaleye, thank you. Precious Esther, thank you. Salif Charles Kamara, thank you very much. I believe we have more people on this call, so I need you all to respond. I am ready to learn. I am ready to learn. Because I'm not the only one here, so let's all participate as much as possible. Okay, so very quickly, so as not Ademoku Inoluwa, thank you very much. So as not to waste our time. Oh, our president is here. Blessing to Jesunimi. Thank you, sir, for honoring us with your presence today. We'll be moving on to the opening address, and the opening address will be taken by Dare Olufunke Elizabeth, who is the Senior Special Assistant to the President. So, Ms. Dare Olufunke, are you on this call now? Ms. Dare Olufunke, you can unmute your mic for the opening address, and if you can, turn on your video camera.
Good afternoon, everybody.
Good afternoon.
Good afternoon, everybody. Can everybody hear me?
Yes, good afternoon from here.
Good afternoon. So my name is Dare Olufunke, and I'm the SSA to the SACOL president, and I'll be giving the opening speech from the president to all of us. So good day, everyone, once again. Welcome to the maiden edition of JUSTICIA CONIUNCTIO, exploring the nexus between criminality, conflict resolution, and the legal system. The president of Student Association of College of Law is excited to dive into today's discussion as we learn and unlearn the nitty-gritty of the law. The entire executives are thrilled to have all of you here. Basically, today's webinar is one of a kind because we get to learn how all these various aspects of law connect and where they do not connect and how it fits into the Nigerian legal system. We have an amazing lineup of speakers who are eager to share their insights and expertise. So get ready to learn, share insights and ideas, and as well as ask questions that are burning to ask things, because your questions and thoughts are what will make today's session truly special. Thank you and welcome once again to the webinar.
Thank you very much for that opening remark. Thank you very much, Mr. Olufunke. So before we move on to our speakers for the day, I have something very little for us all. So when we are talking about the common ground between crime, conflict resolution, and legal systems, does anybody have a rough idea of what that can mean? I mean, if you're in your 100 level or 100 level or 200 level, you should have a rough idea of the common ground that these things have. So before we hear from our speakers, I want to hear from you first. And I'm sure that our speakers would also love to hear from you. So can anybody, somebody that is bold and brave enough to share their opinions with the world, can somebody unmute their mic and give us a rough idea of what they think this webinar is about? Please note that your active participation in this webinar can, emphasis on the word can guarantee you a gift or something from any of the SACOL executives or even our speakers. So please, I would need your active participation for this. So my earlier question, does anybody have a rough idea? Was anybody willing to share with us the rough idea they have of this topic on ground today? I need volunteers, because if I don't get volunteers, I am going to call you out by myself. So please unmute your mic and speak.
Good day, everyone. Once again, I'm sorry for the break in hey, can anybody hear me? Please, can anybody hear me
Yeah,
first?
yeah, we can hear you. Can hear you, sir.
Sorry. Good day, everyone. My name is Fagbon Blessings Jesuni, and I'm the president of the Student Association College of Law. We're very sorry for the break in transition. The host's network is currently misbehaving, so she will join us back in a few minutes. Please just kindly hold on and get ready to learn.
Sorry if I may go. Mr. President, if you could just stand in for her for a while she joins, it will be better because of time. Thank you.
Okay, good afternoon, everybody. I'm so sorry for that short interruption. I had a bit of problem with MTN network. So please, can everybody hear me now?
I can hear you.
Okay, thank you very much.
I can hear you from here too.
Once again, I apologize for the quick break. So before I got cut off by our able network service provider, I was asking that prior to this webinar, I am sure every one of us must have had a rough idea of what the webinar topic is about. So I was telling our president, our amiable president, Mr. TJ Sunime, to please give us his own rough idea of what this webinar topic is about. So, Mr. President, you can unmute yourself, sir.
Okay, good day everyone. Once again, my name is Fagbon Blessing. I'm very sorry if you cannot hear me very well because I'm currently in transit and I'm moving from one place to the other, so my network might probably be breaking. So basically, what the topic for today is the nexus between criminality, conflict resolution, and the legal system. So we all know as law students, there are other areas of law which, as lawyers or as law students or aspiring bar members, we need to be able to look at and examine if we want to venture into. And in Osun State University, we have the Faculty of Liberal Studies, where we have two departments that are peace and conflict resolution and criminology. So this webinar was just in an aim to bring everybody together and show us, this is what the legal system is all about and how we're able to connect through the law, because all of us are lawyers, or all of us know the law, even though not all of us are lawyers. So please, everybody, get ready to learn, and I hope we all enjoy today's webinar. Thank you very much. Sorry, can anybody hear me?
Okay, thank you,
I
Mr.
can hear
President.
you.
I think everybody got what he said. So moving on, Mr. Kalesomi Adilaja says that to him, what they all have in common is promoting a peaceful society where there are no crimes, presence of justice, harmony, and most importantly, progress. So this is a good sum up of what we are here to discuss today. So without wasting much of our time, we'll be going now into the webinar proper, as we'll be having our first speaker in person of Dr. Philip Ademola Olayoku. I'm so sorry if I made a mistake in the pronunciation of your name, sir. Please pardon me. So right now, I'll be reading the citation of Dr. Philip Ademola Olayoku. And as I am reading his citation, I would appreciate it if our digital hands can please appreciate him and welcome him. I mean, we might not be physically present to clap, but we can digitally give him a round of applause. So please, people of God and people of SACOL, please do not disappoint me. So Dr. Philip Ademola Olayoku holds a doctorate in peace and conflict studies from the University of Ibadan, where he taught as an adjunct lecturer. So hearing this, if you're a student of peace and conflict, you still have a long way to go. You have a lot you can do with what you are learning. He's the founder and coordinator of the West African Transitional Justice Center and serves as the chair of Marcel Advisory. Dr. Olayoku's expertise extends to consulting on projects, including the Media and Terrorism Project for the Center for Journalism Innovation and Development, and serving on the International Advisory Board of Medecins Sans Frontières. I'm starting to think this is French, for developing models on their speaking out case studies. His research focuses on transitional justice, security studies, ethnicity, digital power dynamics, and transnational relations, yielding numerous policy and research publications. Recent works include Seclination and Decolonizing Reparations in African Interdiasporic Context, International Critical Thought, Tech Hedonism as Metaverse in the Future of Nigerian Netizens Sociopolitics, Digital Policy Studies Journal, and Anti-Semitism, Intersection of Politics, Religion, and Consanguinity Among Nigerian Jews, Bulletin de l'Observatoire International du Religieux. Oh my God, my French has greatly improved. So if your digital hands are not too busy and if your hands are not too busy to type, please welcome Dr. Philip Ademola Olayoku. By typing, we are ready to have you, sir. I'm expecting more from us. We are ready to have you, sir. Okay, thank you. I'm expecting more from us. We are ready to have you, sir. 3 more responses and Mr. Philip takes the mic. I'm expecting more. Okay, thank you very much. So Dr. Philip, you have the floor now, sir.
Yeah, thank you very much, Ifeoluwa. Can you confirm whether you can hear me?
Yes, I can hear you clearly.
Yeah, thank you very much. So I would love to share my screen if you stop sharing yours so that I can check whether mine would work. So while that's going on, I would love to extend my appreciation to the members of the students association, SACOL, that's the Students Association of the College of Law in Osun State University. It's a rare privilege to be in your midst today, and also with those of us that have a background in philosophy, we believe that we are perpetual students, and so it's always a learning experience for us, you know, to interact with people and also try to build ourselves, you know, in terms of the inquiry that we have. But let me just thank some persons who reached out to me. Of course, Abraham Omorioye, who is the PR of SACOL, I was just harassing before the program that I was sending a message 4:30 this morning. So I was wondering whether you didn't expect that I should even have some rest. But I appreciate his energetic self, you know. Of course, I was recommended by Mr. Tunde Aremu. Thank you for the recommendation. Babatunde Favor was in touch at some point, Gen Sec of SACOL, and also the president, Fagbon Blessing Tijesu. So thank you for the efforts of putting this together. And I hope it's going to be a good learning experience for each and every one of us. Please, if you stop hearing me at any point, don't be alarmed. I've tried to create backup for my internet connection, and hopefully everything will work out just fine. So today, from what was sent to me, JUSTICIA CONIUNCTIO, of course, I looked at my own place of comfort because I'm not a lawyer. Like you've seen, I've been introduced as someone who is more comfortable in the realm of peace and conflict, but I have a background in philosophy, which always creates an entry point to most of my interventions. And so that's why I tried to also look at the state of our nation and couch a topic that I feel brings together, you know, the themes that I want to discuss today: criminality, legality, and conflict management. And I think in all of this, I changed conflict resolution to management because in the peace and conflict studies balance, I think for a while now, there have been challenges, whether, especially from the Western discussions, whether conflict could actually be resolved or not. So people are more tilted towards conflict management. And more recently, you see here we'll discuss more about conflict transformation. So, but let's leave the debates for those guys and let's try to proceed. So, can you still see I'm trying to move my slide. Okay, yeah, so that's fine. So when Abraham reached out to me, I think there was a controversy that was going on in the country at the moment, because our time is fast spent. But I would love somebody to just type in the chat what's this picture, what you think would be a connection between this picture and the topic of discussion today, if you have an idea, you know, because of what was happening in the country at the moment, I decided to take a leave and peep into the infrastructure of our justice system. From what we have learned, if nobody's typing, I'll just continue. From what we have learned from the discussions in the chat thus far, about what the expectations are for this webinar. The first person I saw the response was Kamara, who spoke about criminology being the science of crime. And so we expect to hear something about crime today. And of course, from what is extant in the slide that I'm sharing at the moment, I could say that crime or violation of law, if we could use that word, or commission of an offense, is something that tries to bring all of these people together. And of course, it's aftermath. You know, within the Nigerian scene. The other thing is restoration of peace, stability, and order in the community. That these are the functions of the different fields that we have of study. That's from Precious, which I also agree with, that the end goal of criminology, of the study of law, the legal studies, jurisprudence, and also of conflict management is to create order and peace and stability in the society. And Adelaja was talking about creating a peaceful society where there's no crime, where there's justice, harmony, and progress. Now, we look at the Nigerian scenario. And the only thing I want to say is that labeling this slide, the logic of the Nigerian justice infrastructure, has to deal with how the increasing failed belief in our justice system is bringing up chaos, both in the physical space and in the virtual space, and how we are beginning to have alternative justice mechanisms, in persons like VDM, Very Dark Man, who has become, in a world where influencing is something that is dominant, who has become a sort of the hope, for the hopeless. He's very renowned for helping people recover debts, but he has, transformed into also showcasing the challenges within the justice or criminal justice system in Nigeria, not just in the court of law alone, but also within what is now known as the correctional service in Nigeria. We'll return to this slide, but let's just go back to the topic of the day. So I don't know why the slide is slow. So we have Justicia CONIUNCTIO, which is the theme that we're talking about today. We're going to look at it, one after the other, and I start, with the term Justicia, which of course is the Western paradigm of justice. It's Latin, the Latin word for justice. And I try to go to the etymology of this word for us to even understand what we're talking about. Now, because the Greek system predates or is always the reference point for Western development, Western civilization, we look at how they dealt with the concept of justice, from the ancient times. And if you look to the left of your screen, you'll see that I have the picture of Themis, who is the goddess of justice. Of course, she had to leave the earth within the legend, because of the chaos on earth, and eventually became responsible for several other things. But let me not bore you with that. But what is important, beyond the legend, of course, they tried to create these persons as historical figures. Beyond the legend is the fact that, the conceptualization of justice comes from the word titemi, which is to put in place. To put in place, to put simply, but now within the context is to put something in place. And for the purpose of this interaction, we'll conceptualize this as creating a sort of order. When you talk about putting a round peg in a round hole, a square peg in a square hole, let things be where they are supposed to be, And this informed what we can consider the Greek principle of justice, the Greek principle of justice. And the principle of justice is what? To prosekon ekastos apodidonai, which means that you give each person what is due to the person. Give each person what is due to the person. So put something in place. Let there be things apportioned according to what people deserve. This is what this concept talks about. Just follow me as we follow on this, as we go on this journey. Now, this concept was also different from the positive aspects or the positive approach to law today, to say the pragmatic approach, to say what works within the society. And I explain it better to say that you find increasingly that what's happening within our society is that there's a difference between morality and the law. Increasingly, people are beginning to separate what is moral from what is legal. And what do I mean? You may do something wrong and still, be exonerated as long as in, okay, I mean, these are values that you should be careful in using. Let me not say wrong. You may do something that is considered immoral, within some crimes, which also has to be contextualized, But for our purpose, let's consider that some acts are considered immoral, but they may be validated, they may not be illegal, You may, so some societies, as long as societies has not outlawed some practices, they are considered legal, So, but this is different from the original conception of the term of justice, because morality was a defining factor of what was legal, So, because everything had to be as was naturally ordered by the divine, everything was ordered. It's not today that you talk about choices, to say that the society is imposing something on you, to say that some rights are supposed to be individual rights, and the time you have the right to control a lot of things. I don't want to go into all of those debates, simply because we believe that within the cosmos, there is no enforcement. The cosmos, or the what we consider the natural order, does not have a superimposition on the affairs of men any longer. So I think I've done too much on this slide. Let's go to the Latin equivalent is justicia, that, like we know, just for context, is a Roman myth, that was created by Augustus in 14 AD, and it also, is influenced by the basic principle, "O prosecco ne caso apodidonai," which in Latin means "sum quique tibuere," to each his own. You understand? Given every person his own due. So these are like the earliest beginnings of the Western paradigm of justice. Now, it's important to say that within this paradigm of justice, we can I take my extractions from the Roman code, the Justinian, from the Justinian institutions, which is like the legal code of the Roman law, and I extract an aspect of it. I think is the third session of book 1, Liber Uno, which talks about, or Primus Liber, the first book, which gives us the basic principles of it was like in the very foundations on which the other laws were built: the private law, the public law, the individual law, child rights, and stuff like that, which goes thus: Iuris precepta sunt haec, honeste vivere, alterum non ledere, sum quique tibuere. So how does that translate? The precepts of the law are this: to live honestly. Honesty. We're talking of order. Honesty, giving each person his due. So there's a level of responsibility that is expected from the citizens. There's a level of responsibility not to injure others. That means beyond yourself, you also have responsibility to the other. So you have to follow me. You have to live honestly from your own person. You do not have to harm other people. And the last person is that should anything happen, you give each person what the person deserves. You give each person what the person deserves. What I didn't mention in the last aspects of my discussion when I was talking about justice is the fact that if you look at the images which I think is very important. I can go back quickly to the images. You could see that there's a blindfold on the image, especially of Themis. And if you look closely at Justicia, if you look at the face of Justicia, if you look at how blind people are portrayed, it also gives a reflection of somebody who does not have sight. Now, originally, this was not the portrayal of the concept of justice. And I'll come to that. I'll come to that later in my discussion so that you understand why I'm making this decision. But now, because you have to give each person his own due, that means there's a level of fairness that is expected, and justice is blind to all. Now, I take you back to my own place of comfort, philosophy, and of course, there was a reference about this, what's it called now? This very principle of justice, to prosecon ekastos apodidonai. That's given each person is due. And so Plato critiqued these aspects of justice. Why? Because he felt that when you say that what somebody deserves is what you are going to give to the person, it eventually leads you to, because you are the person that is going to determine who deserves what. That's a subjective perception of determining what the other deserves. And so when you give to the other person what you think the other person deserves, you could also, in your judgment, fail to judge correctly, and so create an ambience of injustice, And so I critiqued it as during his discussions with Polemachus, of course, Glaucon took over, and was saying that Simonides wasn't right when it said that each person should be given his own due. So what was his own proposition to these aspects of justice? And while I was discussing with some of my friends, we came out with this term, ekastos eis ta idea. Each person to his own. Do not forget that when we have been talking about the essence of this discussion, we've been talking about criminology, the law profession, conflict studies, trying to create peace, stability, order, peaceful society, justice, harmony. How does this come about, within the society? We take leave from the suggestion of Plato. It really was, it seems, Glaucon, which is why it helps, a sort of adumbration of justice. This principle that it is right for the cobbler by nature to cobble and to occupy himself with nothing else, and the carpenter to practice carpentry, and similarly to all others. What was Plato trying to create, in this context? What he was creating in this context, in reversing, the te prosepkon ekastos apodidonai, is to say that every person, because remember, we're talking of the right of citizenship, every person contributes his own quota to the society. Every person goes about his business the way he's supposed to go about it. And it talks about the classification of the inner person, the higher, the middle, and the lower functioning of the human person, of the human spirit, human person. And one thing that I emphasized was the fact that there must be a retention of harmony. So the concept of justice, within the conceptualization of Plato, is the retention of harmony within a commune where every person performs, contributes to the development of the society, which means that beyond those who are designated, for representation because of the submission of general will and stuff like that, people have to, take charge. But the principle of justice that can create a functioning society means that every person has to go about his own duty the best way he can and not interfere in every other person's business. The moment there's interference, then it becomes a equilibrium, within the society. It means that the man must not suffer the principles of his soul to do each the work of some other and interfere and meddle with one another. No, every person has his own role and duty, rights and responsibility within the society. And so you must carry that out, in the society. This is very important. And I take you back to the first slide where I showed the challenges within our own correctional service system. You see that the challenge, that brought the controversy was a sort of meddling within the judicial infrastructure, on the country. Someone who was supposed to be kept in custody, someone who had felt he had created a disequilibrium by violating the law of the land, who was also looking for a way to ensure that other people do not carry out their roles. And these other persons did not even carry out their roles within the society. Now, let's leave justice for a moment, because you guys created the problem for me to go back to school. So we'll go to the CONUNCTIO, as a context for our discussion. Now, CONUNCTIO, from my interrogation and finding, has to do with alchemy, alchemy. And the basic text for this, as given, one of the important texts in this in conceptualizing the CONUNCTIO is the Mysterium Coniunctionis, which was focused on Jung's alchemy. Now, the alchemists were fascinated about the representation of nature, of things, through symbolisms, trying to explain the beauty of life, And so these are part of the first author, Edgar's class notes, as put together by a student. Now, let me not bore you with further details. Let's go to what it means. So I broke the concept down into two. There's a process in which the CONUNCTIO comes to bear. There is a process. And you know that when there's a process, there's always something that process is leading to, and that's the goal. Now we're going to start with the process. Just follow me. Now you know that the world is filled with binaries, good and evil, basically, But what these people are explaining, if you could read the slide in front of, okay, let me just read the first part that I highlighted so that I understand. The factors which come together in the CONUNCTIO are conceived as opposites. The factors that come together are conceived as opposites, the keyword opposites, but they are either in confrontation with one another, in enmity, or attracting one another in love. So this goes about your necessary, and I love this very much, because if you look at our own conception of Tibitire within the Yoruba knowledge system, sorry, I know that there are non-Yorubas here, but even within the African cosmogony generally, you will know that there's a lack of exactitude. I give you an expression, that is popularly being advocated for by people who Ifa worshippers. The word for Satan, the word for Satan, for instance, in Yoruba is Eshu. Now there's an argument that Eshu is not Satan. In fact, it's not an argument. There's a lot of advocacy against that, because Eshu is not the devil per se, but Eshu is considered as the god of apostans. Eshu is that midpoint where everything, only, they talk about the orita, a meeting pot, the CONUNCTIO of things. That's what Eshu is. So, and why am I saying it? Within the Yoruba cosmology, Eshu can do good. Eshu can be appeased. You can beg Eshu, you understand, not to do something. You can appease Eshu. You can go and put something, to appease, so that you can avert it. And so what Yoruba people do in the worship of Eshu is for them to say, okay, for instance, as we want to do this webinar now, a fellow has been complaining about MTN data. So in order for MTN not to keep giving us the break that we have, we'll go and appease Eshu, because they believe that it's Eshu, who is the trickster god that plays on all of this. It's just like the Akpos of the, the Akpos mythical figure, or the meme, the Akpos meme in our social media, So that was the person is. So what I'm trying to emphasize here is that there are binaries. There are no binaries within our own concept. So it's either things are opposing each other, but it is also possible for things to be attracted to each other. Why is this important for justice? Why it is important for the concept of justice is that you mustn't see a policeman on the road and be agitated that the first point of contact with the policeman is that the policeman wants to incriminate you. The policeman must not see you on the road and be configured to think that this is a criminal that is coming, as we are wont to do, within our system. Let me not even go to that aspect of security, which I'm very conversant with, because the thing is that the very basis of even founding a police institution in the country is faulted, because the colonialists brought in or introduced the policing system against the citizens, which contradicted our own security architecture. Of course, if you know about the vigilante, the neighborhood watch and stuff like that, the aim of saying every male adult in the community that they should come out to protect the community overnight is to keep everyone safe. The reason why the Onyibo brought police within the African context is to ensure that the people are prevented from committing crime. They are secured. They are. So have you seen the truth? So that means by default, when you become a security agent in Nigeria, you consider every other person. You are looking for a way to put people in place instead of looking for the progress of people. This is not necessarily so, and that is what I want us to take from the aspect of CONIUNCTIO. That's fine. There may be criminals in the society, there may be outlaws in the society, but there are also people that are doing good. And it is the bringing together of all these old, masculine, feminine. They do not need to be opposites. Masculinity, femininity we don't need to be quarreling. The living and the dead even have the harmonious have some sort of harmony within the African cosmogony. When you talk about the cult of the ancestors, the ancestral place, the open and the occult, the active and the passive. This may oppose, and be in enmity with each other when they are used for the wrong purposes, but they can also be used for good. This is very important within our CONIUNCTIO discussion. Now, what is the end product? Which is something that is very important. So when all of this come together, when these different binaries in nature come together, when every aspect of this thing come together, when there's criminality, when there's legality, when there's conflict management in the society, what is supposed to happen? According to the alchemical symbolism, the CONIUNCTIO is the goal of the process. It's the entity, the stuff, the substance that is created by the alchemical procedure when finally it succeeds in uniting the opposites. It is a mysterious, transcendent thing that can be expressed by many symbolic images. And they have a lot of images, but most of these images were very positive about life. I mean, I've given you the reference. It's online. Mysterium Coniunctionis. That's the book. Google it. You can read, you can go it and see how very profound, the description of nature was, by this presence. So what are we saying? What we are saying is that when opposites come together, when there's criminality, when we are trying to manage this criminality, there's something that we are being directed towards. The JUSTICIA CONIUNCTIO. The JUSTICIA CONIUNCTIO. That is the restoration of order. The restoration of order. And that's why when I was beginning my discussion, I was telling you that the common place of all of this, the common place of all of these efforts that we're trying to make, the common place of all of these efforts that we're trying to make is restorative justice, because we're trying to bring something fresh, something new, into the society. Now, this is my own way of describing the matrix. I'm not very good in art, so don't bother. But this is just what I've explained. So see this as opposites, trying to come together, being in conflict with each other. And in philosophy, we talk about the dialectics, of being, the unraveling of being. And it's either you're inverting it, like Marx, or you're going from being as the expression of itself. And so you have the thesis, which you can say something that is positive, the ordered world, those that are abiding by the rules, those that are looking for peace in the community. And the antithesis, the antithesis, which is sorry, I'm getting messages from Abraham. He will not allow me to rest, but I'll be on time. Don't worry. So the antithesis is criminality. Always. So in these are things that are conflicting with each other and lead us to restorative justice. But do not forget that even if I critique my own label here, if I critique the label, this is just for the purpose of this discussion. But if I do a criticism of this label that I have here, then I'm saying that it need not be criminality. It could be something like peace, joy, happiness, wealth, that will come together, in legality and also help to build the society, help to restore the society. So things need not always be conflictual. That's the point I'm trying to make. Now let's bring it home. Enough of all the dancing about the theory. How do we define crime in Nigeria? And so I'm not a lawyer, and so I went to, but because of these kinds of forum, I think it's also good to abide by what we have. The disclaimer is that these are not my own definitions. So any criticism should go to the Nigerian state, because you might have our own reservations about this. But in Nigeria, of course, you know that we try to be one, but also the Criminal Code Act is subsumed under the Penal Code in Northern Nigeria. So, but for the purpose of this discussion, especially because we are within the South, let's just stick to what we are comfortable with. And I'm sure that's what you'll be using in class as well, except for those maybe that are studying Islamic law or something. So what is crime? What is an offense within the Nigerian context? So the thing is an act of omission. So it's either you are doing something or you are refusing to do something. It's either you do something or you are refusing to do something that renders the person doing the act or making the omission liable to punishment under this code or under any act or law. You understand? So the code, stipulated certain kinds of offenses, and the violation of which means that the society is structured in such a way that there is an ordering. There's an ordering that enables people, to act. They're supposed to enable people to act right. They're supposed to be like a guide. So when and that's supposed to create a state. That's what's supposed to enable what, if I could go back to what we spoke about with Plato, everybody going about their own business the way they're supposed to go about it. So that means that the first point of order in the society is the person. And if we have people doing what they're supposed to do within a social structure, social system, there's every chance and every possibility that there's going to be justice within that society. Everybody is going to, have what he or she truly deserves, which also leads us back to the first point. So, by saying that we should go deeper, rather than saying that giving people their due, the first thing is that play your own role first. Play your own role. Do whatever you're supposed to do it. Whatever you're not supposed to do not do it. Okay. My time is fast spent. So let me go to the division. So in Nigeria, you have 3 classes, of course. This is just for those that are not lawyers. But it's very important to also show that the level of creating or violating the societal equilibrium, are classed into 3 different categories, which also means, so some people say sin is sin. And I'm not doubting that. And this, of course, the word sin is religious. We should avoid. By the way, the national prayer is supposed to be our opening prayer. So that makes it easy for all of us. I think with the new national anthem, they have also redefined the stanza that we're supposed to be using. I think it's the third stanza also, if I'm right. So just for learning, because you're all learning, for events like this, it's just best to just flow with the national prayer so that you stop putting people on the spot, you know. So that's that. But so the different classes of offenses, you know, you have felonies, which are like the most grievous ones. So that's treason, like trying to take over government, try to bring war to Nigeria, or the perversion of justice. The perversion of justice, you know, that's actually carrying out the act, meddling with the judiciary. And I brought that out because of the slide that I shared at the beginning, and how VDM came out with an attempt that I felt was like a perversion of justice. So that is actually something that is very topical and something that is very challenging. And that's why the foreigners were not taking it easy, because as lawyers, they knew the implication of what he was trying to bring about. And the other man, Idris, and he identified as a man before the court of law. So I'm just trying to follow that based on his own identification. You know, may not have been aware of these kinds of challenges, and that's why maybe was a bit careless with some of his utterances. But let's not go into that controversy. But I brought up this issue so that you understand that what we are discussing is not very far off from what is happening in our society. So there's a lesser crime, which is misdemeanor, you know. And the challenge, so you disobey a lawful order by constitutional authority, you disobey the president of SACOL, for instance, is a misdemeanor. You know, it can charge you to court and say that, because I hope people have the constitution. So the one that I'm angry with is the misuse of juju, you know, which is a violation of traditional religion. And I think it's still there. I think I saw the version of 2010, the criminal code. Was it 2010? Yeah, I think it was 2010 that I saw. Maybe that was the last edit, but that was the one I saw on the Plaque's website, which is always updating. They work closely with National Assembly, so they usually have the updated version, you know. So, and you have the simple offenses, which are just like the small things. If it's not under either boat, then it's fine. Okay, so we have basically like 5 minutes. So what has happened is that, bringing us back to some of these offenses, when criminality is in this, criminality is a human experience. We should accept that. And when it occurs within the society also looks for a way to manage it as appropriate. You know, you say conflict management, conflict, whatever. So in our own wisdom, we have said that in managing criminality in Nigeria at the moment, we have to shift from prisons to correctional service. And I also went to the Act, you know, which repealed the Prisons Act, the earlier Prison Act. You know, this was made, I think, in 2019. The House, maybe it was signed into law, whatever. But I extracted something that I think are very useful from some sections, you know, for our discussion. Section 2, Section 9, and Section 10. The first thing is, I'm not going to dwell much on this slide, but I just want you to know what is supposed to be obtainable. What is the new correctional service where they hold people that have violated our social order? What is it supposed to do? It's supposed to, 1, ensure compliance with international human rights standards and good correctional practices. Enhance the focus of corrections and promotion of reformation, rehabilitation, and reintegration of offenders, which means that it's not supposed to be a place for the condemned. It's supposed to be a place where humans are restored, where they are brought back, you know, to being able to incorporate them back into the society. And that is the essence of the Operation Safe Corridor, for instance, you know, which was initiated by the military. You know, when we talk about terrorism and violence, you know, what the essence of it is that they look for the low-risk offenders, Boko Haram insurgents. These are people who were forcefully kidnapped. These were people who were threatened to join the group, and they profiled them. And they say, okay, instead of keeping these people in perpetual detention or without charge or stuff like that, let's create a space for them. Let's reorientate them. Let's rehabilitate them. Let's de-radicalize them. And let's try to reintegrate them back into the society, which is the restoration that we're talking about. So for anybody that, so this fits into the African commune. The African commune, where we talk about conflict resolution, where some people emphasize is the fact that every conflict management experience is directed towards the rebuilding of society, the reintegration of the people, and that's why you have some celebrations after some have been some conflicts have been resolved. So you say the parties should embrace themselves. You say this one should keep good and let's celebrate and feast and bring people together. So restoration, and that's the essence of the correctional service in Nigeria at the moment. The second thing is the building, because I don't want to keep us beyond where we're. So the second one is the building, the custodial center. It's supposed to have, Section 9, sleeping accommodation, which meets all requirements of health, with consideration given, among other things, to adequate floor space, water and sanitation amenities, lighting and ventilation, So that's the thing. So you can judge for yourself the images that you have seen about our correctional services, whether the area is comfortable and could accommodate people the way they are supposed to have it. But the essence of all of this is to ensure that people do not go out of the correctional service worse off than they entered, which was the situation in the prisons. They live in very humane, subhuman conditions, so that you become even further hardened, or further depressed than when you were taken there, taken there initially, for correction. The last thing is safety, security, and humane custody for the inmates, Section 10. So it's supposed to be a place of safety. So the thing is that the Nigerian system, I think under the former Minister of Interior, looked at it that it's supposed to be an experience of restoration, an experience where people, come together. Now, in all of this, because I've dealt on some aspects of criminality and stuff, we've dwelt on the aspects of the legal provisions of this, which are tied together. Now, where do my people, conflict managers, where do they come in? We talk about conflict transformation, which is the essence of restorative justice. And like I showed you, in the earlier matrix, restorative justice is supposed to be the goal, the CONIUNCTIO of all of these efforts that are put together. Now, so what is conflict transformation? And I look at John Paul Lederach, who is usually like the father figure of the term, the person who that often has the term associated with him as like the purveyor or the initiator or the originator within conflict studies. And it has a book, the little book of the little book of conflict management. I can't remember the exact name of the book now. I think it's in my references. We'll check it. But he has this book where he detailed the aspects of conflict transformation, and the part of the extracts, from the book is what I bring to you today, to build constructive change out of the energy created by conflict. Now, of course, that for those in conflict management, like we've seen even within our own criminal code, there are layers to the commission of offenses as we have these layers, we also have layers to conflict, which also hinders the equilibrium in the society. Now, the application is not to give me some more time, so that's why. But we're almost done. I'll stop boring you. Now, the thing is that within conflict situations, conflict does not necessarily have to de-escalate or no escalate. Yeah, that's the thing. Conflict does not necessarily have to escalate into violence. You know, different mechanisms, dialogue, mediation, arbitration, negotiation, and you guys have all of that. Of course, this also, you know, is intertwined with the profession of law. You know, of course, when you talk about arbitration, the multi-door courthouse and stuff like that, multi-door courthouse, yeah. You know, so, but why conflict does not necessarily have to degenerate or escalate into violence is the fact that at certain layers of it, when it's considered as a process, there could be some interventions to transform the conflict, to transform. It was a term that was newly introduced, you know, so you had conflict resolution, you had conflict prevention, and all of these terms. So letter says conflict transformation is the goal. And for JUSTICIA CONIUNCTIO, since we are tended towards something, for our purpose, of course, even in that definition of CONIUNCTIO that I gave you from the Mysterium Connuncionis, it need not just be binaries. It could also be a blend of different angles, different aspects of different things, you know, coming together, you know. So, and that tells us that within a conflict situation, it did not also be something that is, it did not be people or groups that are in opposition with each other. It could be a meeting. For instance, as we are having this lecture, all I've said, I'm sure some people will not agree with it, and we may start arguing, you know. But the way we manage the argument is how the argument will eventually turn out. Either to be something that gives us progress, we learn, you know. So if you're arguing, for instance, to build our knowledge of these things, then definitely we're going to bring some sort of new knowledge from our arguments and discussion. But if we are arguing to win, or we are arguing to bring down the other person, then the conflict can degenerate into something else. We stop talking to each other. When there's breakdown in communication, we start mobilizing people, support me. And when there's a breakdown in that, they'll start confronting each other. And before you know it, there's chaos everywhere. So the earlier we try to transform the challenges that we have, the better. And transformation has to take place at different layers, you know, at the personal level, which is what we have been saying. Each person, Ekastos, A star idea, each person to his own, going about his own duty. Relational, because you're also interacting with the other, giving each person his due. To prosecon, Ekastos, that's it. You know, sorry, I need to take some water. To prosecon, Ekastos, apodidonai, you know, that's each person getting his due. In Latin, sum quique tibuere, you know. So that's the relational aspects of it. So this all comes together. You start from the person, then the relation of the person with the society, because we are social beings. Then when you can deal with the other people, you also need to transform the structures, because when we come together to say we want to operate, there are certain guidelines. The Nobel Prize in Economics this year, for instance, was awarded to people. Of course, I criticize them, but I need to cite them for, there are some things that we can learn from their work, you know, to say, because they say that issues that were created by colonialism have helped some countries develop. I think that is a violation of the experiences of those who suffered under colonialism. But the importance of it is that they said that for societies to develop and grow in political terms, politically and economically, then they have to have very strong institutions, very strong institutions. INEC has to work well. The police have to work well. The Osun State University has to work well. SACOL has to, whatever has been designed to serve its own purpose is functioning properly. And that is when all of these structures are functioning together, then the society can make progress in terms of its political economy. So that means you also have to transform the earning structures. And that's what I think they were trying to do with the correctional service, even if it's been marked. But it's in law. And we're hoping that one day we'll get to that. Then there's a cultural dimension, which I think is very important. You know, people think that when they talk about culture, it has to be something archaic. And of course, you know that that's not necessarily true. Culture is always being bred. Culture, as defined, you know, by some guy from Frankfurt, I think was it Guy Debord, I'm not very sure now, is a conflict between tradition and innovation. Tradition, which looks at the past, the way things are done. Innovation, which looks at the present, you know. And innovation always superimposes itself on tradition, and that's how we are able to, innovation superimposes itself on tradition, and that's how we have new cultures. So innovation of technology is what is affording us the opportunity to be able to have this discussion on Zoom. Otherwise, you guys will have been looking for a way to get me to Ifetedo. I will also have been looking for a way to get to Ifetedo. But things are evolving, things are changing. There's a new academic culture, you know, and so culture itself needs to undergo transformation in order to breathe in fresh air to the society, to recreate the kind of equilibrium that is expected, you know, within the society. I think my time is up now, and I'll just say all the things I've been talking about since morning, I've leveraged the strength of my friends who are language experts, you know, Father Dr. Franz Adelabu, Mr. Pine Momo, Mr. Eyinon Perez Ayeka, who is with us here. You know, I thank them for their support. And I also thank all of you for your wonderful and kind attention. And I hope that I've not confused you more. Like you see, I'm not an expert in this area, but I hope that this brings up new discussions for us to be able to learn, you know. Thank you very much. Let me just look for the Lederach book I was talking about. Yeah, the Little Book of Conflict Transformation. That's the name of the book, you know. You can get the details on conflict transformation on that. So thank you very much. I think I have to yield the floor back to the moderator. Thank you.
Thank you very much, sir. So in the chat box, can we give him a round of applause? I mean, I've learned a lot, and it was amazing to know the origin of these words and trace them back to where they really came from. Thank you very much, sir. I'm sure that the whole body of SACOL appreciates your time and your expertise this afternoon. So very quickly, we would not be taking questions yet. We'll be postponing the questions till after the second speaker session. So if you have a question, please pen them down, keep them somewhere, write them in your jotter, and we'll take them after the second speaker session. Or if you have questions, you can send them to Mr. Abraham, the SACOL PRO, and make sure to communicate your questions. So right now, we'll be moving on. I'm sure that we've gained a lot. From the first session, I gained a lot. I'm sure that we are well fed, but the feeding is not complete. Carbohydrates without protein and the other parts is not a balanced diet. So now we want to get balanced diets. We want to combine it and get good food. So we'll be moving on to our second speaker in person of Barrister Gafar Okunlanwo, who is an associate at Stream Sowers and Con. Please, can his profile be displayed as I read his citation? Okay, thank you. As we also did for the first speaker, please, as I'm reading his citation, let us appreciate him. This citation So please pay attention as I read the second speaker citation. And just as we did from Dr. Philip, please let's also appreciate Mr. Gafar as I read his citation. Gafar Okunlanwo attended Obafemi Awolowo University, where he graduated as one of the best students in his set. Before then, he attended Moshood Abiola Polytechnic, Abeokuta, Ogun State, where he has a national diploma in mass communication. He also attended the Nigerian Law School, Lagos campus, for his vocational training to be qualified as a barrister and solicitor of the Supreme Court of Nigeria. Before he joined Stream Towers and Con, a top-tier law firm, he practiced journalism and he had used this to build several opportunities for himself in the legal and media industry. Gafar Okonlawan's flair for litigation, courtroom advocacy, and alternative dispute resolution has made him appear in various cadres of courts in Nigeria, including the High Courts, Courts of Appeal, and various mediation and arbitration centers. He enjoys mentoring, with which he has employed in building effective student leaders across different institutions of higher learning in Nigeria. By now, I expect the chat box to be filled with applause. Gafar Okonlawan is passionate about law as a tool for social re-engineering. This has allowed him to carry out notable research in the areas of recovery of premises and land disputes, intellectual property, particularly in the area of patent and pharmaceutical, jurisdiction of courts, human rights, and not lawyers' rights, just to mention but a few. To wit, he has been on the verge of becoming not only a senior advocate of Nigeria at exactly 10 years of active practice, but also a renowned professor of law in the university. When Okonlawan is not representing clients in courts, he is reading law reports, researching, watching movies, and discussing law-related matters with his colleagues, friends, and those who are passionate about legal developments within and outside Nigeria. So if you are delighted to have Mr. Gafar Okonlawan here with us today, please welcome him with the chat box and show your utmost excitement. Thank you all very much. Mr. Gafar, you have the floor now, sir.
Thank you very much. I really appreciate. Good evening, everyone. I'm glad to be here today. I must commend and appreciate the first speaker for the knowledge exposing segment. To continue from where he stopped, I think it's actually necessary to understand the fact that what we've come here to discuss is the union of justice. And trying to look through the Union of Justice. Oh, I need to apologize for something. The slides, due to technical error or technical issue, is not available, but the organizers will make it available after this segment. To which we intend to look at the relationship that transpired between criminality, conflict resolutions, and legal system. You all agree with me, as a matter of fact, that defining a concept showcases the fact that we are killing that concept because we don't really have a precise word to disclose reality. Bearing this in mind, we want to look at, in the modern society, these components we've identified or pointed out, that is criminality, conflict resolution, and legal systems, are things we want to use in maintaining law and order. As a matter of fact, criminality represents actions that threaten social harmony, just like the previous speaker has mentioned. Not only that, infringe on individual and collective rights. You all will agree with me, the popular saying that has turned to a cliche in our society and within the legal space, that abuse of right begins when you use your right to affect someone else's right. Conflict resolution provides, on the other hand, provides mechanism for addressing disputes and preventing escalations. The question will now be conflict resolution. How is it distinct from alternative dispute resolution? Is there alternative dispute resolution in criminal litigations or criminal issues? These are things we look at holistically to arrive at how we can position our legal system. This presentation, therefore, will look at the three elements and how it interrelates, focusing on their symbiotic role in social stability, restorative justice, and societal transformation. Bearing in mind, as a matter of fact, that there is no way we want to do justice to the issue on ground without making reference to the sacrosanct 1999 Constitution. As students of law or those who are not within the scope of the law, you understand the fact that in this 1999 Constitution, there are 820 sections and we have 8 chapters. This is a lay down principle, and we have a particular provision of the law, that is section 1, subsection 3, that states that if there is any other law that is inconsistent with the provision of the Constitution, that other law, to the extent of its inconsistency, shall be null and void. But how do we arrive at that? Before we arrive at that, it's an indication to showcase that we must have a workable laws in place. And just like the previous speaker mentioned, in fact, he has done brilliant work, and I must commend Doctor for such brilliant presentation, in the sense that we need to look at the position of ACJL, Administration of Criminal Justice Act 2015, with respect to what law is in the federal level, and we need to look at some states in question now, that's the Administration of Criminal Justice Law, since the university in question situates in Osun State. Of course, reference needs to be made to the ACJL of Osun State. It will have been other thing if the university situates in Lagos, and it will have been Administration of Criminal Justice Law of Lagos State. But not to bore you with a lot of rhetorics, meaning of some certain terms need to be put forward. Criminality refers to behaviors and actions that violate legal norms and disrupt public peace, ranging from theft and fraud to organized crime, terrorism, and violent conflict. Ladies and gentlemen, it arises from complex factors, including poverty, social inequality, lack of education, and weak institutions. Besides, criminal acts undermines rule of law. Everyone understand the indispensable role of rule of law. And as student of history, Thomas Hobbes, in his postulation, while trying to make reference to social contract, trying to expatiate on the fact that in the state of nature, can you hear me? Can you hear me, please? So Thomas Hobbes
Yes,
trying
you
to
can
state
hear
the
you.
fact that, okay, in the state of nature, all right, thank you very much for the feedback. Like in the state of nature, things can be what nasty, brutal, short, and isolation. And in order for us not to move back to state of nature, that's one of the reasons why this particular discussion is sacrosanct and in fact important. So, like I've mentioned, that criminal behavior often emerges in societies where structural imbalances exist. For instance, economic deprivation. Look at the word economic deprivation. It is one of the things that can actually cause crime in the society. And within the legal jurisprudence, you understand the fact that there is a particular part of our constitution, and that's chapter 2 of the 1999 constitution, that addresses fundamental objectives and directive principles of state policy. Things within chapter 2 of the Constitution, by virtue of section 66C of the 1999 Constitution, presume that, okay, things highlighted from section 13 to section 17 to section 20 of that particular aspect are non-justiciable. But you agree with me that economic objective is also one of the key things that government need to put in place in order to prevent crime. Hence, reference is being made mention here to the fact that for crime to occur in the society, economic deprivation, marginalization, and lack of employment opportunities may, emphasis on that, may push individuals towards crime as a survival strategy. Additionally, weak governance, corruption, and ineffective policing exacerbate the problem by creating loopholes in law enforcement and accountability. Criminality also has broader implications for communities. High crime rates can diminish trust in institutions, discourage investment, and force people to live in fear. Beyond the immediate victims, communities as a whole bear the social and economic costs of crime. Thus, tackling criminality requires multifaceted strategies that not only involve punitive measures but also address underlying socio-economic causes. Ladies and gentlemen, that's just the overview of what criminality is all about and why do people commit crime. The other issue to tackle herein is conflict resolution. Conflict is an inevitable part of human society, but unresolved or poorly managed conflict can escalate into violence and criminal behavior. Conflict resolution is the process of addressing disputes through peaceful means to avoid or mitigate violence. It encompasses that it ranges, it's moved across, it's just like in international commercial arbitration, or what we call commercial arbitration. There is what we call there's what we call ADR, that's alternative dispute resolution. And there are mechanisms, there are tools, and those tools highlighted or pointed here with respect to conflict resolution is the fact that we have negotiation, we have mediation, we have arbitration, and we have reconciliation. So there has been an argument over the years with respect to the fact that is there the word crime, does the word crime actually acknowledge or appreciate alternative dispute resolution? Is plea bargaining equivalent to alternative dispute resolution? Please follow me while I address or highlight those issues. Effective conflict resolutions, ladies and gentlemen, plays a crucial role in mitigating criminal behavior if we have identified, as a matter of fact, that economic factors, marginalization, and some other things could actually push people to commit crimes. We are now trying to point out that effective conflict resolutions plays a crucial role in mitigating criminal behavior. When conflicts are not resolved, they can create conditions for criminal activities such as extortion, assault, and even organized crime. A prime example is in communities where land disputes evolved into violent confrontations, resulting in loss of lives and destruction of property. In the absence of effective resolution mechanism, parties may resort to illegal means to assert their claims or protect their interests. This still takes us back to the fact that in the state of nature, things will go nasty, brutal, short, and isolation. So in order for us to have a clearer picture of a sound and sane society, bearing in mind that we're coming from criminality to conflict resolution, and we want to look at our legal system. How has our legal system tried to put holistic structure in place to address issues we're trying to identify? More so, conflict resolution contributes to restorative justice, just like it has been mentioned by Doctor in his presentation, which focuses on repairing the harm caused by criminal actions, rather than merely punishing offenders. They discovered the fact that this part of my position is what has put us in a situation or an unending argument with respect to the fact that should we continue to acknowledge or appreciate death penalty in Nigeria. And someone once or long argued in a philosophy class rather, that when you look at death penalty, it's just like a means of trying to tell people who have killed people that killing people is the best way to kill people. That in itself is a philosophy question. Ladies and gentlemen, mediation processes that involves victims, offenders, and the community allow for dialogue and reconciliation. Restorative justice provides an alternative to retributive models by promoting healing and reintegration, thus reducing the likelihood of reoffending. So the essence of having conflict resolution is to reduce the amount of crimes being committed in the society. Now, what is the position of our legal system with respect to criminality, with respect to conflict resolution? The legal system serves as a framework through which criminality is addressed and conflicts are resolved. It is a structure of institutions, laws, and procedures designed to maintain social control, enforce rights and obligations, and uphold justice. Just like I would like to make reference to Section 1, subsection 1 of the 1999 Constitution that says that, okay, this Constitution is supreme, and its provision shall have a binding force on all authorities and persons throughout Federal Republic of Nigeria. It's because of the fact that we have a sound legal system in place. The sound legal system, with respect to Section 1, subsection 2 of the 1999 Constitution, that addresses Section 37 of our Criminal Code. In if there are actually, like, you have people who are aggrieved, who intend to hijack or who intend to take over the way and manner the state is being governed, you believe or you succumb to the fact that such act or such action could be tagged treason or treasonable felony. Why do we come to that realization? We come to that realization because of the fact that we have a legal system in place that has spelled out or that has put in place the consequence for a particular action or consequences for an action. Just like the way we have in our criminal code, section 357 of the criminal code, that defines what amount to rape. It means the fact that if you have actually committed an offense, there is a punishment for such offense. We have that as a reminder because our legal system has actually made provision for that. And as students of law or as lawyers in the house or those who are not within the legal profession, there is one thing we always say, and it is a Latin maxim, that ignorantia juris excusat. Then we have what ignorantia facit, ignorantia juris non excusat, ignorantia facit excusat. What is the meaning of ignorantia facit excusat? Meaning that ignorant of facts, it is excusable. Ignorantia juris non excusat, meaning that ignorant of the law, it is not an excuse. So if you're coming from the point of criminality, you want to annex to conflict resolution, then you want to bring it down to our legal system, you discover that our legal system is just like a watchdog. It's just being put in place to checkmate and to prevent societal disorder. Because when you look at the provision of section 14(2)(b) of the sacrosanct 1999 Constitution that states that the heading of that particular section is government and the people, meaning that section 14(2)(b) of the 1999 Constitution states that the security and welfare of the people shall be the primary purpose of the government. Hence, legal system is being put in place for government to perform its sole duties and responsibility. In addition to this, it is a structure, just like I've mentioned, it is a structure of institution, laws, and procedures designed to maintain social control, enforce rights and obligations, and uphold justice. Legal systems operate at both formal and informal levels. Formal institutions include courts, police, and correctional facilities. Just like doctor has actually mentioned the aspect of the correctional facilities, then the police, the role of the police, as we all know, the police are actually meant to protect peace and order internally. And the court, just like we know, is the last hope of the common man. With this position, I want you all to understand that one of the primary roles of the legal system is to define what constitutes crime and to prescribe punishment accordingly. Let us go back to legal methods. There is a particular popular case known as Aokofagbemi. In Aokofagbemi, what happened in Aokofagbemi? In the northern part of the country, adultery is actually a crime. In the southern part of the country, adultery is not a crime. Meaning that the essence why we have a legal system in place is to checkmate, is to prescribe, is to put in place how things are meant to be done Hence, you cannot be punished for an unwritten law. You cannot be punished for a law that is not known. Moving forward, ladies and gentlemen, one of the primary roles of the legal system is to define, just like mentioned, what constitutes crime and prescribe punishment accordingly. Criminal laws set boundaries for acceptable behavior, providing a deterrent effect against potential offenders. And that's when you look at Section 7 of the Criminal Code. Then we begin to look at, okay, what is the mens rea? What is the actus reus? So you want to look at, okay, who is the principal offender? Who is accessory? These are things that our laws have actually put in place for us not to act outside the scope of the law. Just like Williams Laxton once mentioned, that it is better to let go. It is better to let go of 9 criminals than punishing one innocent person. And that is why in criminal law or in criminal litigation, however we want to put it, what we are interested in is what we want to prove beyond reasonable doubt. Therefore, the legal system provides mechanism for conflict resolutions. How? Courts offer a formal setting for adjudicating disputes, and for adjudicating disputes with decision based on legal principles and evidence. In many jurisdictions, alternative dispute resolution mechanisms such as mediation and arbitration are promoted to complement the formal court system. Now, I have a contrary opinion with respect to this particular position. And what is the contrary opinion with this particular position is the fact that it is easier for us to actually acknowledge or appreciate alternative dispute resolution in civil matter than the way and manner in which we actually treat or appreciate alternative dispute resolution in criminal matter. There has been plethora of arguments from scholars as to whether or not the word plea bargaining equates alternative dispute resolution. And the conclusion is plea bargaining is not the same with alternative dispute resolution. These alternative dispute resolution processes provide faster and less adversarial ways to resolve the conflict, particularly in matters involving commercial or family disputes. Look at that. Res ipsa locutor. The fact speaks for itself. In matters what? Involving what? Commercial or family disputes. Legal systems, however, are not without challenges. In many countries, especially in developing nations, weak institutions, corruptions, and inadequate funding impair the effective delivery of justice. It's like this general position of what we actually most consider the fact that why do we have law? We have law in place to guide people. And where people misbehave, we want to run to court. What are we looking out for? Why are we running to court? We want to get what? Justice. Then if our idea of justice is totally far from what effigy of justice represent, then it is no longer justice. On this note, delays in court process and lack of access to legal representations can erode public trust in the legal system, leading to frustrations and sometimes even vigilantism. Thus, reforming legal system to ensure efficiency, transparency, and fairness is critical to their effectiveness in addressing crime and resolving conflicts. So, if we want to address crime and we want to resolve conflicts, there is need for us to address our legal system. As a worshiper in the temple of justice, there are a lot of things that still need to be corrected. When you look at the provision of the Constitution with respect to Section 235 of the 1999 Constitution, you question ourselves the fact that, okay, the Constitution expressly mentioned the fact that, okay, we actually have what? 21 justices in the Federal Republic of Nigeria, in the nation, in a country with over 200 million. meaning that as at today, we have some matters before the Supreme Court, that is the apex court of the land, that will come up in 2030, that will come up in 2028, that will come up in 2029, and we are now in 2024. Another aspect of this presentation is the intersections of criminality, conflict resolution, and legal system. Justice will not be done to the issue at hand if we fail to look at the intersections of criminality, conflict resolution, and legal system. The intersection between criminality, conflict resolution, and legal systems lies in their shared objective. And what is that shared objective? Fostering societal order and justice. When there is peace, there is harmony. Criminality threatens the foundation of social harmony, but effective conflict resolution, ladies and gentlemen, can prevent criminal behavior by addressing disputes before they escalate. And reference is when you actually look at the way and manner some things are actually being done, the way and manner government intend to address some basic things and all, those things might have not degenerated into what later happened if necessary actions have actually been put in place. Meanwhile, legal systems provide the institutional framework within which both criminal behavior and conflict are managed. One area where the nexus becomes apparent is in the handling of communal violence and ethnic conflicts. You agree with me today that in Nigeria, for instance, clashes between farmers and elders over access to land and water resources have escalated into violent confrontations resulting in death and displacement. Criminal elements often exploit such conflicts, engaging in cattle rustling, kidnapping, and armed robbery. How then do we address this issue? Addressing these issues require not only legal sanctions against offenders, because we'll discover the fact that we have punishment. We have people being punished over the years, and people did not stop committing crime. Then what then is wrong with our legal system? Addressing these issues requires not only legal sanctions against offenders, but also conflict resolution mechanism to address the underlying causes of the dispute. If the purpose of a thing is not known, abuse itself is inevitable. Another area is in transitional justice framework, where post-conflict societies attempt to rebuild through a combination of legal measures and reconciliation process. Countries recovering from civil wars or authoritarian regimes often establish truth commissions and special courts to deal with past crimes. These processes combine, look at, to deal with past crimes. If you're familiar with the Okuta panel, a lot of things was actually put in place and all till date what happened. These processes combine legal accountability with conflict resolution effort to promote healing, reconciliation, and sustain peace. The interplay between criminality and legal system is also evident in criminal justice reform initiatives. In many jurisdictions, overcrowded prisons, just like doctor mentioned and cited different examples, issues with respect to health and every other things, and what the act is yet to address, and little of what the act has actually addressed. Overcrowded prisons and high rates, limitations of punitive justice. As a result, there is growing emphasis on restorative justice approach, which integrates conflict resolution principles within the legal framework. These approaches focus on rehabilitating offenders and reintegrating them into society, thereby breaking the cycle of crime. I think one of the reasons why we have the name Nigerian prison to correctional being changed is the fact that we want to give these people sense of belonging. We actually did not want to create a social opprobrium. We actually don't want them to feel isolated. We want them to come back to the society and think, oh, they've been reformed. What then is the position of the legal jurisprudence as regards crime and conflict? In Nigeria, the nexus between crime, conflict resolution, and legal system reflects the complexities of maintaining peace in a multi-ethnic and socio-economical diverse society. We have over 250 ethnic groups in Nigeria. We have over 400 languages. Nigeria is a state and not a nation. Hence, to fight crime, it's going to be a difficult one. Crime in Nigeria manifests in various forms, including armed robbery, terrorism, kidnapping, internet fraud, and in the loose sense, yahoo yahoo, and communal violence. These crimes challenge national security and economic development. You agree that this crime challenge what national security and economic what challenge? Because when you go back to the wordings of the Constitution, you look at Section 11 of the Constitution, and you go back to Section 14(2)(b) of the Constitution previously mentioned. Security and welfare of the people shall be the primary purpose of the government. All these things are things that actually what disturb sane society. Communal and ethnic conflicts, such as recurring clashes between farmers and elders in the Middle Belt region, often escalate into violent crime, including cattle rustling, kidnapping, etc. Not only that, ladies and gentlemen, these conflicts expose the limitations of law enforcement and emphasize the need for alternative conflict resolution mechanism. When we have crimes, and these crimes are not properly being measured, it actually exposes how the foodie-doody, that's the ineffectiveness of our laws. Then the best way to actually reassure or put hope in people is for us to resort to conflict resolution, another mechanism. Traditional conflict resolution system involving community leaders and religious figures are often employed to mediate disputes. However, the formal legal system through the police and courts plays a vital role in prosecuting crimes arising from such conflicts. Look at traditional conflict resolution and look at the formal conflict resolution. Another example is Nigeria's response to terrorism and insurgency in Northeast driven by Boko Haram. While military intervention is central to combating insurgency, ladies and gentlemen, the government has also integrated conflict resolution measures, such as the Operation Safe Corridor program, which offers de-radicalization and reintegration for repentant militants. You know, the way and manner people conceive things at times actually differ. At some point in time where some persons who are actually were repentant of Boko Haram had to come back and government decided to welcome them, decided to promise them so many things and all, people conceive it from another perspective. But it's also a strategy to there might be an argument with respect to this. But it's also a mechanism to also give room for what? Conflict resolution. Nigeria's legal jurisprudence is also evolving towards restorative justice. For instance, the Administration of Criminal Justice Act 2015 promotes alternatives to imprisonment, such as plea bargaining and community service, meaning that plea bargaining is not the same with alternative dispute resolution, it's just close to it. Reducing prison overcrowding, growing overcrowding, and fostering offender rehabilitation. This demonstrates apologies for that. This demonstrates the growing recognition that effective crime management requires a balance between punitive justice and conflict resolution strategy tailored to Nigerian socio-cultural reality. please. Then what then are the challenges and recommendations? Despite the potential synergy between criminality, conflict resolution, and legal system, there are significant challenges in achieving seamless coordination. Weak institutions, corruption, political interference, and lack of resources often undermine the effectiveness of legal system. Emphasis on what? Political interference. More so, societal attitudes towards conflict and crime can hinder the adoption of restorative justice models, with many people still favoring retribution over rehabilitation. To enhance the effectiveness of this interconnectedness system, several recommendations are essential. I want us to look at this recommendation, despite the fact that we've been able to identify the challenges. It is also good for us to look at the recommendations while moving forward. Government must invest in strengthening legal institutions to ensure that laws are enforced efficiently and fairly. When Professor A.B. Dicey, that's a professor of law, propounded rule of law, the mindset, the notion behind it is what? Equality before the law, impartiality, and what? Right of an individual. And that's what we also encountered. I could remember then in year 1 or 100 level, the best way to actually explain the efficacy of justice, and that is the lady justice, is through the definition of rule of law. So it is important for the sake of our discussion and in this gathering for us to understand that government must invest in strengthening legal institutions to ensure that laws are enforced efficiently and fairly. How are we going to go about this? How will government arrive at this? This includes training law enforcement officers, equipping the courts, and improving prison conditions. Doctor also made reference to this particular point. On the other hand, also, encouraging the use of alternative dispute resolution mechanism to reduce the burden on former courts and ensure faster resolution of disputes. More so, tackling socio-economic inequalities and providing education and employment opportunities can reduce criminal behavior. When you look at the statistics and you look at the unemployment rate, you will see why people commit crime. But that is not a just reason to commit crime. The other point is embracing restorative justice practice. When we embrace restorative justice practice, we can reduce and promote reconciliation between offenders and victims, sensitizing communities about the importance of conflict resolution and restorative justice can foster acceptance of these models. Ladies and gentlemen, the organizers of this webinar, in their wise opinion, have come to the conclusion that Justicia CONIUNCTIO is the appropriate word to use herein, and that is the word union of justice. Hence, Justicia CONIUNCTIO encapsulates the intricate relationship between criminality, conflict resolution, and legal system. These elements work together to uphold justice, maintain social order, and foster peace. Mind you, criminality poses a threat to societal stability, but conflict resolution mechanism can mitigate disputes before they escalate into criminal acts. Look at people who are agitating for this state, for this state, for this, for this, for this. The way and manner things are being handled also define the outcome of it. The legal system institutionalizes these processes, providing a framework for addressing both crime and conflict. However, achieving synergy between these components requires overcoming institutional, social, and economic challenges. Today in our courts, if people are aggrieved, when you look at section 15, talking about the political objectives, section 16, talking about the economic objectives, section 17, talking about the social objectives, section 18, talking about the educational objectives. If people are aggrieved about this, government will hide under these guys of section 66C of the 1999 Constitution that these things are non-justiciable. These things they are just mere things that government need to provide. Government is not, you cannot force government to do those things. Do you know where people run to? People run to chapter 4 of the Constitution to challenge the inactions of government on issues we have in chapter 2 of the Constitution. Meaning that for us to have a stable and sane legal system, there is need to achieve and put a proper focus on how we can bring a synergy between the components of institutionalizing the social and economic challenges with the right reforms and a holistic approach. The nexus between criminality, conflict resolution, and legal system can serve as a foundation for sustainable peace and justice in the society. Thank you.
Thank you very much for that insightful session, sir. I'm sure everyone, personally, I had a lot to gain, and I'm sure everyone had one or two things to take away from this session. Thank you very much once again, sir, for sparing us your time and your knowledge. So we do not have so much time left, and we'll be moving on to the questions. So if you are still on this call at this moment, and if you have questions for any of the speakers, please, you can unmute your mic. We are just taking 2 questions because of the limited time we have. So if you have questions for any of the speakers, we are taking 2 questions from 2 participants. Please, you can unmute your mic to speak, or you can type it in the chat box. But we would prefer you unmute your mic to speak because of the time limitation. So we have 2 participants to ask questions. So please, if you have a question, please unmute your mic. I'll be giving us 1 more minute to make up our minds. Yes, thank you very much. That was a nice presentation, yes. But if you have a question, please let's make it quick and ask our questions. Thirty more seconds, and I'm closing the window to this question and answer session from the participants. Okay, since no one has a question, I'll be reading out 2 of the questions we received prior to this webinar. So the first question is targeted at Dr. Philip. So the question states, how can the Nigerian police force improve its investigative techniques to reduce false confessions and wrongful convictions? How can the Nigerian police force improve its investigative techniques to reduce false confessions and wrongful convictions? Dr. Philip, that is for you, sir.
Okay, do I go ahead? Can you hear me?
Yes, sir. We can hear you.
Yeah, sorry, it's raining. It's raining now, so I hope that the internet still permits us to. Fortunately, I was part of the process of trying to work on the new Police Act, which has been on, since like 2000 and, or even before the 2000s. I'm not very sure, but let's say since the return to democracy, eventually we have the 2020 Police Act. And I'm going to the base because I like to go to the roots of issues so that we'll know where the problems are. Now, I mentioned during our discussion that of into Nigeria has its own challenges, and that's why it appears that the institution has been configured
Dr. Philip, sir, we can no longer hear you, sir.
Yeah, sorry. I actually went off. So can you hear me? Is it better now? Like the network
Yes,
was
we
bad.
can.
Is it better now? Yeah. So what I was saying is that the person who documented the Nigeria policing system for his doctoral degree, Professor Tekena Tamuno, gave us the insight into the reasoning why it was created, which was to put the Nigerian people in order rather than for their own protection and security. And why am I emphasizing this? The reasoning behind why things are created are very important in understanding where the challenges of the operation of these things may be. And because of time, let me just go straight to the point. So the new Police Act was created in order to, among other things, ensure the human rights angle to policing in Nigeria. I think they try to integrate an aspect of community policing in it, and also give some certain guides in terms of code of conduct, to the press. So the outlines are there, or the guides are there, but the challenge now is the awareness. Of course, let me not say that it's not the version of the Police Act that we would have desired that was eventually approved, but at least you have something that was different from what was given to us in the colonial era. So what we are saying is that first, for them to be able to carry out their work professionally and appropriately, which includes not forcing people to confess,
false confession and doing proper investigation, they have to already know the content of this new act, which I doubt a lot of them know. You understand? So the fact is that there needs to be a process of enlightenment to say, even the correctional service, I doubt if a lot of people who are operating within the correctional service have an idea of what it is. Ditto for all the security agencies that we have in this country. So the first point of call in building, because I think the question is about professionalism, in building the professionals is to ensure that first they know the content of what they are supposed to operate with. And two, to have an institution that is functional to enable them to operate within the provisions of this, you know. And finally, to have occasional and ongoing human development trainings for each of these persons, you know. I just because of time, that's why I'm trying to summarize so that I allow the second speaker. Sorry, that's rude to say the second speaker. I don't want to pronounce his name wrongly. Is it Mr. Gafar? To make his own contribution. Thank you very much. Yeah, Ifeolu, are you there? I think I've finished.
All right,
Okay.
sir. Thank you very much for that. So the second, okay, so it's Mr. Olivia has a question here, and I'll be reading that out. It says, I would like to ask the presenter, what is the gap between our countries in Africa and others in developed world when it comes to criminal protections and legal system fulfillment? Is there a gap between those two different areas? Thank you. Mr. Gafar, please, I don't know if you would like to take this question, sir. See here.
Okay, can you hear me, Ifeoluwa?
Yes, clearly, sir.
Please, can you take the question again, please?
Okay, he says, I would like to ask the presenter, what is the gap between our countries in Africa and others in developed world when it comes to criminal protections and legal system fulfillment? Is there a gap between those two different areas? Thank you.
In as much as I don't actually like to speak negative of a legal system, the question has actually put me in a tight corner to state the obvious. And you agree with me, by or in classification, just like from the economic point of view, you say, okay, we have developed countries, we have developing countries, then we have underdeveloped countries. This same classification, as a matter of fact, is also applicable in the way and manner in which crime is being conceived, in which the offenders are being protected, and in which the mode of operation is being addressed. So when you look at the foreign or the Western countries, you notice the way and manner in which protection is being done. But when you look at the part of our home country here, not just Nigeria now, when you look at other African countries, regardless of the classification, maybe you want to look at it from the West African countries, you want to look at it from the South African countries and all, you understand that we are far from reality. You understand that we are not there yet. And to just use what Dr. Philip has actually addressed the other time to show a lacuna or a loophole in what it is here in Africa, Nigeria to be precise. Is the question being asked with respect to way and manner the police address issue as regards confessional statement and professionalism? There has been plethora of Supreme Court cases and decisions on how to go about confessional statements, on the procedure laid down by the Administration of Criminal Justice Act. The way and manner confessional statement is expected to be taken is far from the way it's being conducted. This is one of many of the issues that we still have, that these people are criminals. It is not an avenue to subject them to unnecessary procedure that is not being done over there. And this will also point our attention to way and manners we use the word accused. You say, okay, this person is accused, okay, this person is offender, this person is guilty at all. So I feel the manner in which we actually address it boils on our exposure, and as a matter of fact, it cuts down to our understanding of the concepts in question. So mindfully, I would say that we are far from where we need to be in Africa, and we can still do better and we can do more if we allow professionalism to override mediocrity. Thank you.
Thank you very much, sir. Olivia, I hope that answer was to your satisfaction. You're very welcome. Thank you once again, Mr. Gafar. So we are drawing close to the end of this webinar, and I am glad to inform you that you've learned a lot. I have learned a lot, and we are not leaving this webinar the same way that we came into it. A lot of things have been revealed to us. A lot of systems have been broken down to us. So I would encourage us that when you go out and you talk to people, you ensure to pass on the same knowledge that you've gotten to them. So to wrap up this insightful webinar, we'll be having the closing remark from the Vice President of SACOL, who is Bankole Ayomide Gideon.
Good evening, everyone.
Good evening, you can go on.
My name is Bankole Ayomide. I'm the Vice President for the Student Association of College of Law. Thank you all for joining today for this enlightening webinar. As the Vice President, I'm honored to share this experience with such a distinguished gathering. To our esteemed speakers, I extend my deepest gratitude for sharing your expertise and insights. Your contribution has enriched our understanding of the nexus between criminology, conflict resolution, and legal system, and inspired us to evolve new perspectives. To our participants, thank you for your active engagement and thought-provoking questions. Your participation has made a webinar a resounding success. As we conclude today's discussion, I encourage you to continue exploring the ideas and concepts presented. May the knowledge gained today ignite meaningful conversations and pour positive change in our legal community. Just before we close, I would like to extend my thanks to the organizing committee, the PRO in particular, sponsors and technical team. I also love to invite us to visit our college website for events and updates. And I would love to encourage us to give feedbacks and suggestions for future webinars. With all this said, I declare this webinar officially closed. Thank you once again. We look forward to connecting with you soon. Goodbye.
Thank you so much for that, Bankole Ayomide. So once again, I would like to say a very big thank you to everybody for participating in this webinar. I mean, at the beginning, I asked us not to disappoint me, and we didn't disappoint. So thank you very much. To the speakers, Dr. Philip and Mr. Gafar, thank you for sparing us your time and your knowledge. We hope that any other time that we call on you, you would answer us with all of your time and all of your attention. And to the planning committee, the president, the vice president, the general secretary, the PRO, thank you so much for bringing up this wonderful initiative. And to the participants, once again, I say thank you. I hope that anytime we call you to participate in anything, you would show up in your numbers. Thank you very much. And it was nice being your host for today. My name is still Ifeoluwa Akinshola, and have a wonderful rest of the day. Thank you all very much.